The civil justice process really begins with the filing of a lawsuit. That is, one party has been harmed by another, and they go and they tell the court. And that notifies the court that the court needs to begin monitoring this case and supervising it. And then the complaint gets served on the defendant, and that's when really the process starts. And the court's monitoring the parties, and the court is trying to work on getting the case moving towards a trial date. Really, the process involves three different aspects to it. The first is the discovery aspect. The second is the dispute resolution process aspect. That is, the court tries to get the case settled short of trial. And then the third aspect is the trial process. The discovery process is a general overview or umbrella to describe what happens for the first 6 to 9 months of a case. The parties are exchanging information with one another as they're learning more about the claims and the defenses in the case. That usually takes the form of written questions, and it also can take the form of oral deposition testimony. That is, where the defense attorney would ask my client about how the injury has progressed over time and how it's affecting their life, and I would be taking testimony from the defendant about what they did to cause or contribute to the injury. And that process, again, will take 6 to 9 months. Once the discovery process is done and the parties have the information necessary to present the evidence to an arbitrator or to a mediator, then we get into that second process, or that second aspect of the civil justice process, which is the settlement process. And the court orders the parties generally to participate in an arbitration or mediation. An arbitration is a hearing where we have a judge that decides what the value of the case is based on the evidence. So the parties present the evidence to a neutral third party, and that person gets to hear the evidence, gets to meet the parties, and gets to determine what fair value is. Now, when they write that award can be rejected by the parties because it's non-binding. So it can be useful, it can provide some guidance on what a neutral thinks the value is, and it could ultimately lead to a resolution of the case. A mediation is a bit different in that it's a neutral third party, but that person, instead of being a judge of the evidence, acts as a facilitator between the parties. They will talk about the highlights of the evidence, the lowlights of the evidence, things that the parties need to consider that will happen at trial, and we'll try to get the parties to come to a meeting of the minds and come to some sort of an agreement as to what a fair settlement value or fair settlement range would be. The goal, of course, being that a settlement gets reached and the parties are able to put the matter behind them. If the ADR process or the dispute resolution process fails, then the end solution is the trial process. And, of course, throughout the course of litigation, we work very diligently on making sure that we have all the evidence necessary and are equipped and prepared to do the trial process, because we have no assurance that insurance companies are going to do the right thing for our clients. And so we're always mindful that we may need to try the case. Every client I talk to tells me, I don't want a trial. Nobody likes their life being put under a microscope or likes to have to be judged or looked at in that fashion. But the reality is that there are certain cases that need to go through the trial process. I would tell you that 90% of the cases, civil justice cases, resolve short of trial. So it's the rare occurrence that a case does go to trial. But you want to make sure that you have an attorney that is comfortable doing the trial process and a firm that has a reputation for trying cases. That will make certain to get you fair treatment, or at least give you the best opportunity to get fair treatment from the insurance industry. And the trial process is kind of self-explanatory. Most people have a general sense of what a trial involves. I mean, it's not Law and Order, it's not the same thing that you see on TV, but what it is it's the ability of a jury of your peers, 12 people from our community, to assess what you've been through and to assess what the injury is doing and how it's impacting your life. And it gives them the ability to decide what's fair in our community. And they do that by hearing the evidence, by finding out what happened and how it's affecting you and how it's going to affect you out into the future. That process takes time. It takes time to present that evidence to a jury. It takes time for them to understand it. It takes time for them to get a handle on what is going on and what they need to decide. And in my experience, most jurors work very hard to do the right thing for the people that come to the court system for justice and fair treatment. And so if you find yourself in a position where you need a trial, it's not something to be afraid of. It's just something to be cognizant of and to consider in making your decisions as you go through the litigation process.